Welcome, sir. Welcome, Honorable Justice Shri V. SRISHANANDA, sir, Judge High Court of Karnataka. Welcome to the program, sir. So, good evening to one and all present here. So, Vignaneshwara Pratisthana Trust and Central University Kalburgi and Karnataka State Law University jointly organizing this online lecture series in commemoration of 95th birth anniversary of Justice Dr. M. Rama Joish. So it is a memorial lecture which is being organized in commemoration of 95th birth anniversary. And Vignaneshwara Pratisthana Trust has taken efforts to organize many lectures, and today is the final lecture. And today we have with us the chief resource person, Honorable Justice Shri V. SRISHANANDA, sir, who will be addressing on the topic Ancient Bharatiya Jurisprudence and Modern Justice Delivery, Integrating Traditional Wisdom with Digital Innovation. So with this, we formally start this particular today's program. On behalf of Vignaneshwara Pratisthana Trust, CUK Kalburgi and Karnataka State Law University, now I invite Dr. Vaishnavi, Assistant Professor, Department of Law, Central University of Karnataka, Kalburgi, to welcome and introduce the resource person as well as President and Guest of Honor for today's function. Madam, over to you.
Thank you so much, sir. A very good evening to one and all present here. A memorial lecture acquires true meaning when it goes beyond the remembrance and carries forward the intellectual values, ideas, and concerns associated with the personality being commemorated. It is in this spirit that we gather this evening to remember Honorable Justice Dr. M. Rama Joish, and at the same time engage with questions that are deeply relevant to the future of law and justice in India. It gives me immense pleasure to welcome you all to Justice Dr. M. Rama Joish Memorial 6th Online Lecture Series 2026, organized by Vignaneshwara Pratisthana Trust, Mathur, in association with the Department of Law, School of Legal Studies, Central University of Karnataka, and Karnataka State Law University, HON'BLE, to commemorate the 95th birth anniversary of Honorable Justice Dr. M. Rama Joish. Today's lecture is very significant for two primary reasons. Firstly, as already stated, it is the fifth and final lecture in this particular series, and it is highly significant for its theme. The theme is the Ancient Bharatiya Jurisprudence and Modern Justice Delivery, Integrating Traditional Wisdom with Digital Innovation. The theme invites us to reflect upon how much the jurisprudential traditions of Bharat can engage with the rapidly changing landscape of modern justice delivery, particularly at the time when technology is increasingly transforming courts, legal practice, and access to justice. It is our great privilege this evening to have Honorable Justice Shri V. SRISHANANDA, Judge, High Court of Karnataka, as a distinguished speaker. Honorable Justice V. SRISHANANDA was born on 29th March 1966. He was appointed as an additional judge of the High Court of Karnataka on 4th May 2020 and became a permanent judge on 25th September 2021. In his tenure, he has dealt with a wide range of legal issues spanning civil and criminal law, procedural law, intellectual property law, family law, taxation, and matters of public administration. May I request the audience to kindly mute yourself? Thank you so much. My apologies for the same. His judicial work reflects an engagement with both the enduring principles of law and the evolving challenges confronting contemporary justice and delivery. Considering the theme of today's lecture, we could hardly have a more appropriate person to guide us through the interface between Bharatiya jurisprudential wisdom and the contemporary justice delivery system. Honorable Justice SRISHANANDA, sir, we are deeply honored by your gracious presence and sincerely grateful to you for accepting our invitation to deliver this memorial lecture. A very warm and respectful welcome to you, sir.
Namaskara.
It is now my privilege to introduce the distinguished academician presiding over the Professor Dr. C. Basavaraju, Honorable Vice Chancellor, Karnataka State Law University. Professor Basavaraju is an eminent legal academician, researcher, and academic administrator. He has held several distinguished positions, including the Vice Chancellor in charge, Registrar, Syndicate Member, and the Academic Council Member of the University of Mysore, besides serving as a Registrar Evaluation of the Karnataka State Dr. Gangubai Hangal Music and Performing Arts University, Mysore. He began his career as a law teacher at the NLSIU Bengaluru in 1995 and later joined the University of Mysore, where he served in several capacities. His academic work has a strong focus on constitutional law and social justice. His doctoral research was on social justice with special reference to SC/ST under the Constitution of India. A prolific scholar, he has published 125 research papers, authored 4 books, and presented 175 research papers at national and international seminars and conferences. He has successfully guided 18 PhD scholars and more than 160 LLM dissertations. Professor Basuraj, sir, your distinguished contribution to legal education, research, and academic administration, and the cause of social justice, and make your presence especially meaningful on this occasion. We are deeply honored to have you to preside over today's program and extend you a very warm welcome, sir.
Thank you.
We are equally delighted to have with us our esteemed guest of honor, Professor Dr. V. Sudesh, Principal, Postgraduate Department of Law, University Law College, Bangalore University. Professor Sudesh is an alumnus of Bangalore University. He has completed his BA LLB in 1991, LLM in 1993, and obtained the PhD in labor law in 2005. With more than 28 years of teaching and research experience, his principal areas of academic interest include labor law, intellectual property law, and jurisprudence. He has successfully guided 11 PhD scholars and has made significant contributions through his research publications and presentations in international and national forums. During his career, he has served as an officiating Vice Chancellor of the Bangalore University, Dean of the Faculty of Law, Chairman and the Principal of the University Law College and Department of Studies in Law, member of the Syndicate of the Bangalore University, and ex-officio member of the Karnataka State Law Commission. Professor Sudesh, sir, your vast experience as a teacher, researcher, and academic administrator adds immense value to this occasion. We are truly honored for your presence and extend a very warm welcome, sir.
Namaste, thank you.
I also take this opportunity to warmly welcome the sitting and the former judges of the High Court of Karnataka who have joined us this evening. Honorable Vice Chancellor, Professor Bhattu Satyanarayana, Central University of Karnataka, Deans, Head of the Departments, Principals of various institutions across Karnataka, Shri Amit Kumar Deshpande, Senior Advocate, High Court of Karnataka and Trustee of Vijnaneshwara Pratishtana Trust, Mr. Mahadevayasha, Trustee, Vijnaneshwara Pratishtana Trust, Dr. Girish K.C., Coordinator, Center for Research in Democracy and Constitutional Government and Center for Research in Water Resource Management and Law, Karnataka State Law University, Dr. K.M. Krishna Shekhar Sharma, Assistant Professor, Department of Law, Central University of Karnataka, and all those whose efforts made this lecture possible. On behalf of the organizers, I once again
I think there is some technical problem. Thank you for such a wonderful welcome and introduction of the dignitaries to the program. And I welcome Dr. Vaishnavi, Assistant Professor, Department of Law, Central University, Karnataka, to this program. Thank you for the wonderful welcome address and introducing the guest, madam. And once again, I request all the participants to keep your video and microphones switched off in a switched off mode. Only when it is necessary, please switch on your videos as well as microphones. Now it is a much awaited time. All of us are waiting for this moment to listen to a lecture. And today's resource person is Honorable Justice Shri SRISHANANDA sir, Judge, High Court of Karnataka. And sir will be delivering a lecture on the topic, Ancient Bharatiya Jurisprudence and Modern Justice Delivery, Integrating Traditional Wisdom with Digital Innovation. Sir, we are eagerly waiting to listen to you, sir. Over to you, sir. Thank you.
Namaskara. Am I audible?
Yes, sir. Yes, sir.
Greetings to one and all. I am told that this is the last lecture in this year's Dr. M. Ramajoy's Memorial Lecture Series. You had all beautiful lectures till now, some of which I could also be benefited. Today's function rather online lecture is presided over by Dr. C. Basuraju, and Dr. Sudesh is the guest of honor who have shared the virtual dais with me. As usual, the persons who have joined this online lecture series do have some idea of what the topic is. Our endeavor all along is to see that while we are aware that the constitutional values and the legal system that is prevalent in India must be followed, no second word about it. In fact, when I have emphasized the value system, the legal system that we had, we cherished, which ruled this country several centuries, there were few misquotes as well that I was advocating for the same system. To clarify the same, I am making it very clear in the beginning of my lecture itself. The whole idea is to see that not to discount or not to follow the present system. I am aware and my position demands that there should not be any tinkering with the existing legal system, or should there not be any discount to the present legal system, which we have agreed. Constitution is supremo, and therefore any laws that are enacted thereunder, we are required to implicitly obey and follow the same. With that few introductory notes, let us see the topic, ancient Bharatiya jurisprudence. I don't know, the organizers have used the word in the place of Indian, the Bharatiya, in commemoration with the 150th year of Vande Mataram, as well as the recent amendments to the Bharatiya Nyaya Samhite, Bharatiya BNSS, and then BSA. I have emphasized in many lectures the word Bharatiya assumes a greater importance in all these aspects of the matter. Let us not deviate from the subject. Therefore, it should be looked into ancient Bharatiya jurisprudence and modern justice delivery. Of course, that is what we have now, the system, integrating traditional wisdom with digital innovation. So the subject has got three parts. So when we understand or slice it down, the topic would be, first and foremost, would be what is ancient Bharatiya jurisprudence. In my understanding, with the available texts, including the famous book Legal and Constitutional History by Dr. M. Ramajoyce, which is the guiding book for me to be here and then speaking few words. Our jurisprudence, or Nyaya Shastra, Bharatiya Nyaya Shastra, was deeply rooted legal tradition. The system was centered around what is called the word dharma. My dear friends, the dharma, when you give it to the Google or try to understand what the dharma means, many would mistake it with or equate it with the word called religion. I am sorry, that's not the intention or the definition of the word dharma. Dharma is something more than that. You can see the book written by Honorable Justice Ramajoyce on the dharma itself. What the dharma means is not what the religion is about. It is not Hindu religion. It is not any other religion in the world. A dharma is basically a code of conduct. So code of conduct encapsulated itself into it a comprehensive framework combining moral duty on one side, ethics on one factor. Purpose is to see that the social order is maintained. In Dikshitulu versus State of Andhra Pradesh, Honorable Supreme Court had the occasion to deal with this word called dharma, wherein their lordships have expounded the word dharma and then gave a meaning that dharma means it sustains the society. That's the main purpose of the dharma. It maintains the society. It maintains the social order. It works for the development of the society. Several other things are there. Interested people may look into that judgment. So basic idea is to see that blending of moral duty and ethics so as to maintain social order. What was it? Why it was required? To maintain peace and harmony in the society. Friends, we have seen in the recent past, war between two countries in the globe resulted many economic factors in our country as well. Look at the oil prices that has gone up. Consequently, the commodities, 60 rupees a kg of rice is now being sold at around 90 to 100 rupees. You may ask me whether the war has got anything to do with this. Yes, diesel prices have gone up, petrol prices have gone up, labor has gone up, inflation rate is increased. Why? Because two countries in the globe are fighting and we are affected. So, for the development of the society as a whole, what is required is the social order, peace and harmony. This can be achieved when you have a sound judicial system, legal system in a country. Otherwise, the effects are seen in the recent past across the globe. You can take out the names, and those countries are suffering because of the want of proper legal system being there. Otherwise, it will result in chaos. Society will be without any control. Therefore, the dharma, the code of conduct was required into, which will ultimately help what? The governance of the particular state rather than a commanding state. Please understand these two things. I'll give an example. A war is going on. Two troops are there. One troop is led by one commander. Another troop is led by another commander of the same particular nation. One commander says, "Come on, fire." Yesterday, day before yesterday, there were many casualties. 4 and 5 people are left in their particular camp. They are not prepared to obey the commander. They know non-obedience to the command will result in a worse situation like court-martial, etc. They were not on that. So still, they understood what? They did not obey him. In the next camp, another commander says, "Come on, boys, let us fight." So it is leading from the front. Both are commands only. If it is a state command and the subjects are already suffering, they may not obey it. But if you make it as a governance, then though it is a command, it is in the form of a proper governance. This is what has been dealt by Dr. Ramajoyis based on the Yajnavalkya Smriti in what is called Raja Dharma. So now you see, code of conduct, the word dharma gets a different meaning. Raja Dharma is what was told, and that is the basis. Needless to emphasize, Shrutis were the first primitive forms of our code of conduct, or the word dharma, or the jurisprudence. Shrutis, as you know, are not, which could be taken note of for the simple reason what has been heard may be a distorted version also. Then they came what is called Smriti, which was written. We have texts that are available now: Manu Smriti, Yajnavalkya Smriti, Narada Smriti, Parashara Smriti. All these things dealt with in detail many things about the governance of the state. Then came what is called Kautilya's Arthashastra or the Chanakyas. Now, in the Manu, if somebody studies, one should not be mistaken that, that's a totally discarded version. We must go back to the place, time, when the Manusmriti came into picture. Today, much is commented on Manusmriti for various reasons. Yes, understandable. Many portions of the Manusmriti may not be congenial in the today's world. Absolutely no problem on that. But how a system existed. We also have several systems across the globe, in the West also. Those practices are not in place today. But as a person, a student of law, a person who wants to know how the law has evolved, how the justice system has evolved, how the jurisprudence got evolved, it is necessary to find out what was available in a particular country at an undisputed point of time. My dear friends, in this regard, please look into the Kenny's Outlines of Criminal Law, a British jurist, Kenny, he writes in that book that till for advent of 14th century, Britishers did not know the word crime. Please note this. Anybody can refer to this. Kenny's Outlines of Criminal Law. What is the crime is the chapter. While dealing with it, it is the Western jurist Kenny, Professor Kenny, would write that Britishers did not know till up to the advent of the 14th century what is the definition of the word crime, nor they did not have the concept of the crime at all. Alas, if they did not know the word crime, we have been taught Criminal Procedure Code, Indian Penal Code and other penal statutes directly, which are all the colonial statutes. As you know, those colonial statutes are the one which held the field, are holding the field. Inasmuch as law in India is often understood through the lens of colonial codes, statutes and constitutional doctrines. Well, it is the Britishers who left the legacy on us. They did not know the word crime till the advent of 14th century. We did not define the word crime either in the Indian Penal Code or in any other penal statute, including the Criminal Procedure Code. Why? Because they did not know till the advent of 14th century. Kenny further writes, in the advent of the 14th century, Britishers had a hazy idea, please note this, a hazy idea of, or the very primitive form of the word crime. He called it as felony. In contrast, what we had in Bharatiya Jurisprudence at the 3rd century, as accepted by the Westerners, we date it still earlier, as accepted by the Westerners, in the contextual terms, 3rd century text, Smriti, contained not only the definition of the word crime, which he called it as pataka, and it was divided into 2 portions, classified into 2 portions. And it would happen for, pataka will happen for woman and the property. Ondu hennigagi, ondu mannigagi. He classifies it. Not only that, among the patakas, among the crimes, he has created a gradation, which is the grievous offense, which are all the offenses which would not fall under the what is called the grievous nature or the simple crimes. So the Pancha Mahapataka, he said, in the Pancha Mahapataka, we see criticized is one such Pancha Mahapataka. So the text in the Manusmriti did not have all at one place. It was spread in different chapters, and therefore a person who wants to learn what is the Bharatiya Jurisprudence based on the Manusmriti will have to read the entire Manusmriti as a whole and then try to collate from there what are the provisions which would be put into the what is called the jurisprudence. Because Manu did not specifically say anything in the chapter wise. Then came the Yajnavalkya Smriti, more structured, more defined, chapter-wise, dealing with the requirements, civil rights, criminal justice system, how about the master and servant relationship, principle of res judicata, how to protect the victim, how to protect the witness. In my another lecture, I have detailed it out. For paucity of time, I will skip those aspects of the matter because of the fact that I'll have to deal with modern justice delivery system integrating the digital innovation. So these were the law that were available in the, say, 4th century. Let us take it, Yajnavalkya, if you trace it to 3,500 years or so, then it may be around end of 3rd century or 4th century. A beautiful book is written in Kannada by an author from Kalburgi. I would request our Mahadevaya to keep that copy in our Pratishtana. Srinivas Sirnurkar has written Yajnavalkya Smriti in Kannada. I had Mitakshara and the Yajnavalkya Smriti, which my professor had written. Unfortunately, it is now mutilated. I was not in a position to lay my hands onto it. Am I audible?
Yes,
Yes,
sir.
audible, sir. Audible, sir.
Yes, please. So then what happened? This book I wanted to rely upon while delivering a lecture in Central University some time back. But what happened there was that book was so mutilated that I could not carry. So I requested one of my friends who are also working in law colleges as professors and practicing advocates. They tried to lay hands, but they could not also get it. Later on, 15 days later, he came and then gave me a photocopy spiral bounded. Then it so happened that the book contained the first page wherein it has been written as www.forgottenbooks.com. Hope this would reveal and our roles in understanding and studying what was available in our country and then rejuvenate. I am glad that such programs are organized every year while celebrating the birthday of Honorable Dr. M. Rama Joyce. Thanks to the organizers, thanks to the Karnataka State Law University, Professor Basuraju is my friend.
Thank
He
you,
has
sir.
heard such
Thank you,
lectures
sir.
from me earlier. Whenever it is possible, he would be present despite his busy schedule. He would not miss out these type of lectures. I'm sure some student would be interested in understanding this ancient jurisprudence what we had. Across the country, Vijnaneshwara Pratishtana is doing a good job. Recently, my brother Justice Indresh delivered a lecture on the almost similar issue in Assam, where the university had called him. So the idea is like-minded people are now joining together. Two advocates from Tamil Nadu have shown interest. They have studied Yajnavalkya Smriti. They also delivered a lecture in Central University, presided over by Honorable Justice Abdul Nazir Saab, who is the governor of Andhra Pradesh. And he inaugurated that one day's workshop. A district judge from Bihar had made a lot of study on this. With these particular aspects, when we see the jurisprudence, how it developed, as I put it across, smritis are the first and basis for our jurisprudence to develop. Every walk of life is discussed there. I have, in fact, my thesis to Masters of Law to HON'BLE University is on the same subject, namely forms of jurisprudence under Hindu jurisprudence. Forms of contract under Hindu jurisprudence. In that context, I came into contact with all these smritis thanks to my professor. I seek always his blessings. Professor B.N. Sampath was a Hindu law professor in Banaras Hindu University. He will be blessing me from the above, who is no more, who visited Vijnaneshwara place in Martur. In fact, few days thereafter, he left this world. Maybe that was his last wish as well. He is the one who introduced me to the Smritis first time. Now what happens is, if somebody is interested, they may go to Pune and necessarily visit Bhandarkar Oriental Research Institute, where these Smritis are even now available in the original form on the palm leaves. Unfortunately, no Indian goes there. It is the foreign people who come there. I asked on the day when I visited the Bhandarkar Oriental Research Institute, why only foreigners come? A volunteer there who was attached to me, was a lecturer, told me, sir, they don't have any extra love for our country or our jurisprudence. They have all stolen away our smritis at some point of time. I may be excused for using the word stolen away. Anyway, it has reached them in the way that is known. History cannot be wrong. And they come to Bhandarkar Oriental Research Institute for the purpose of missing pages. Now we understand what the glory we had. And unfortunate situation that now we are not in a position to understand and appreciate such beautiful concepts that were there. As I mentioned in the beginning of the lecture itself, my job here is not to degrade any system or the existing system in this country. We are bound by it. I am not discounting it. At the cost of reputation, I am making it. But if we understand, if a professional, if a student, if a lecturer, academician, anybody, common man understand what was the law in this country, the best practices there, the best principles there can be easily imported into the present system and work out a better justice system in the existing system. In that score, we may also take help of the digital innovation. That will cover the today's topic. So, salient features that we had, as I put it across to you, Smriti, then we had what is called Arthashastra, which reflects the influence as well as the limits in the constitutional framework. The very knowledge that was available in this country was not available across the globe when they were still in the primitive stage of their life. Inasmuch as meeting the two ends itself was difficult for them. As such, they could not think of civilization. When there was no civilization, there is no question of any governance. And when there was no proper governance, there was no question of development of the jurisprudence. We were taught many things in our college as well. Curriculum, what was prescribed by the government, was taught to us. We can't have any quarrel with that. Now what we understand is, Indian jurists saw law rooted into higher principles. This is where one has to look into. So when you have a better or a qualitative, a higher jurisprudential value against another primitive nature, naturally one has to look into, and what was available there must always be blended into the present system as well. No doubt, many such things are now taken into consideration while we enacted the new 3 laws in the criminal side, but still lot of other things are to be worked out. Dharma, as I put it across to you, being the code of conduct, introduced what is called a flexibility in understanding. Interpretations were permissible. What was the place that where the law is to be looked into? Nativity was taken into consideration, which they called it as Desha. And they were aware that a particular piece of law may become obsolete over a period of time. For example, today, when we are into the digital world, the pornographic material is not printed today as it is to be about 3 decades, 4 decades earlier. We have in the digital forums now in a palm top. What laws we can now have to control that? We don't have. Unfortunately, an youngster, a school going by, 7th standard student, primary school student, he is now having access to that material. What law we are having? What law we are having? Time should say. We don't have. We have seen what has happened in Delhi public school about 8 to 10 years earlier. Having a pump tap material, what resulted it we know. Way back in the parliament, when the then minister Sushma Swaraj wanted to have a digital check, it was opposed. Today we are seeing why POCSO cases rise. What is available on the palm top is now being into practice. I am just giving one example. So the then jurists of our jurisprudence also spoke what is called kala or the time. Then the third factor that they introduced was patra. This word patra means the person and the surrounding circumstances. So the deep-rooted higher principle surrounded on 3 aspects, namely Desha, Kala, Patra. So the jurist said, what is applicable to one particular place may not be applicable to the other place. For example, AC may be a very good innovation when you have a place where the sun is on, the mercury is on high. But that AC is of no use when you go to a colder country. Unfortunately, Germany is now thinking of importing lot many air conditioners because this summer they could not tolerate the temperature went up to 35, 40, which was never in their history. So the Desha, Kala, Patra, the concept that the Indian jurists had in their text in the Dharma was enough to control the required, desired effect on the upkeeping of the social order. See, this is what one has to look into. The whole purpose of any enactment is to upkeep the social order. Why social order? Because of the proper governance. Why proper governance? Otherwise, society will become chaos. There is no peace and harmony. Therefore, this was required. So this interpretive role that was required to be followed by the courts was told in the text. The king was the judge then. King was not having any independence to decide the case. We see in every order in India, we are the courts of law. Therefore, you often see judgments from the apex court and all courts in accordance with law. So the king, even in the ancient jurisprudence in India, was not free enough to decide the case in a particular manner. No sovereign power was there when a king presides over the court. She was guided and controlled by what is called the dharma or the smriti. So the king was only required to adhere and then implement the what is there told in the books. In other words, she was also controlled by the present day word called statute. So this is where one has to understand how beautiful this system was. When I say this, naturally, I will have to quote again. Many of you have heard this. Many of you are aware of it, which I quoted in one of my court proceedings as well, which is a very important aspect which the Ramajoy's legal and constitutional history quotes it. The case of Sridhara versus Mahidara. I'm only just giving an example there. Sridhara versus Mahidara is a 3rd century case. It was a case of a just recovery of money. Sridhara has invested 2000 dramams. Dramams was the currency in Pataliputra, present day Patna, with Mahidara's great-grandfather for the purpose of the interest. It was a deposit made by Sridhara, invested with the Mahidara's great-grandfather, 2000 dramams, and 200 dramams was the monthly interest he used to get. Sridhara got for a couple of months. There was a great famine at that point of time, a pandemic like COVID what we had. Mahidara's father, grandfather and great-grandfather died in that calamity. Now, Mahidara is holding that 2000 dramams, being the only heir of their family. Sridhara demanded the money from Mahidara, the interest and the principal. Initially, Mahidara was interested to pay it off. But when he consulted the advocate, name is also found, if I am not mistaken, his name is Smartha Dhurandhara, the senior counsel. So he says, according to law, you are not bound to pay, so don't pay. Such a reply was given, matter went to the court. So now the plaint is for recovery of the money by Sridhara against Mahidara of 2000 dramams, which was invested as the principal with interest. Written statement was, yes, we admit that 2000 dramams was invested, but as per the doctrine of pious obligation, I am not liable because the law says Pautraihi. Pautraihi means grandchildren, not great-grandchildren. This is the written statement taken by the Mahidara with the aid of the senior counsel. Matter comes before the court. This is where the interpretive role of the king on the text was required for the following the, Raja Dharma, to uphold the values, to uphold the system, sustain the social order, sustain the societal interest. Now the king, being the judge, is confused. He looks at the statute and then says, yes, he is not liable as per the interpretation of the law as it exists on the face value. Pautrai ends with the grandchildren, not great-grandchildren. Mahidara is a great-grandchild. So therefore, if you go by the only the letter of the law, then he is not liable. Now, in the 3rd century, please mind, when people did not know what is the law, in the 3rd century, this great country thinks of what is the social order, if such pleas are to be allowed, and it would amount to injustice and societal interest against the detriment. It is detrimental to the societal interest is what worked in the then king's mind, that is the judge's mind. So what he does is, he makes it as a referral point and refers the matter to the jurist, the Pandita Sabhe. Today also we have a reference to the larger bench. Larger bench, then so many other things, 3 judges bench, 5 judges bench, constitutional bench, 7 judges bench, etc., etc. That was also available then. Whenever there is a doubt with regard to the implementation of the statute on its own, there was a scope for referring the matter. See the beauty of the system that we had in the Raja Dharma or in the form of the conduct that is to be looked into while conducting the cases. So it's a simple civil case. Recovery of money. Raja does it. Raja refers to the Pandita Varga, the expert committee. Pandita Varga deliberates on pros and cons of interpreting the law. Then, after sufficient deliberation, they come out with an answer. Yes, in the true sense, in the first look, if we look into the law, what we can do is we can only work it out to that Mahidara is not liable, but one other factor that is to be looked into. Doctrine of pious obligation is a doctrine where even if no assets are received from the ancestors, the third generation has to repay those debts so that his ancestors, the grandsons or grandchildren's ancestors attain moksha or sadgati. So based on that, the doctrine of pious obligation had come. But in the case on hand, since Mahidara received the proceeds which his great-grandfather left, that is the property that is left behind by his great-grandfather, they come out with a beautiful answer called liability passes on with the property. My dear friends, anybody who practices on the civil side today will understand and can correlate this with the Order 21, where if a money decree is there, the first requirement for the decree holder to establish before the court is to show that the legal representatives of the original debtors has retained the property of the original debtor and therefore they are liable. What is available today in the modern concept was given to the world in the 3rd century by the then king. And this is the Pandita Varga's opinion on the reference. Reference is answered. Now the matter comes back to the court. King is there to interpret it. Now look at it. It is the task of the judge, the king, to implement this. So he not only implements and decrees the suit. Suit of the Sridhara was decreed as prayed for. King did not stop there. This is the best part of any jurisprudence which one would be cherishing even today across the globe. If somebody comes to know about it, he did not stop at the decreeing of the suit as prayed for, cost, etc. He goes a step further and says, look, you have taken a plea which is detrimental to the societal interest. It may be to protect your client Mahidara, but your interpretation in not paying the money and giving a strict interpretation in the form of letters, not in the form of spirit. Therefore, the sanadha of the senior council's Martha Durandara was cancelled by the judge. What more you want? You have now pleading in the form of plain written statement, issues. Then there is a difficulty with regard to the interpretation of the statute. Then it was referred to the expert committee. Opinion has come. Reference is answered. Suit is decided as per the reference. Punitive action for taking a false plea, wrong plea, detrimental to the interest of the society. Now you understand what is told in Dikshitulu versus State of Andhra Pradesh, that dharma sustains the society, dharma protects the society, dharma works for the maintenance of the societal interest. What is more is required. This was what our text was. Even on the criminal side, we had wonderful judgments, but today's context that may not be the relevant because many of those laws are not in existence with the present day constitutional aspects. We have the beautiful concepts on the Evidence Act. For example, whenever there is a boundary dispute, how it was being decided is told in this Smriti. In the Yajnavalkya, he says, to demarcate between the two lands, about 3 to 4 feet or 6 feet down the earth, it is to be dug, and non-perishable like items like lime, then coal, all these things are to be put in earthen parts, and it is to be dug there, and it is to be kept there, and the soil is to be closed. Whenever a dispute arises as to the boundary, if a lawsuit comes to the civil court in the boundary dispute, then a commissioner would be appointed who goes there, digs the place where the existing boundary was there, and if these particular things were found in that particular boundary, then the boundary dispute would be solved. If any person has encroached upon, not only the civil dispute would end, but it would also be punishable. Now look at, compare this with Order 39, Rule 2A. In how many cases we have punished the person who have violated the injunction? In how many cases we have put the exemplary cause? Look at all these things. These are the principles that we can take it, borrow it in the modern system as well, and then find out. See, appointment of the commissioner, then going to the spot, making a spot inspection, Order 26, Rule 9. Will it not be akin to the what was available about 3,500 years earlier? What a beautiful system we had. Cherish this. Understand this. Then you will have the scope. Then you will have the value for the word dharma, satya. Honorable Justice Malimat in his report has given what is the purpose of a trial. Senior Malimat I am speaking of. Purpose of a trial. His Lordship would write it. The purpose of the trial is a voyage. What is the destination in such a voyage? The whole purpose and the gamya or the destination in such voyage is unearthing the truth. Unearthing the truth. Meaning thereby, truth should triumph all along. All along, truth should triumph, not the asatya. Then you have a judgment called, reported in AR 2006 SC 1367. Please, all of you, I would request you, my earnest request is to go through the judgment. Honorable Justice Arijit Pasayat has quoted 2 stanzas from the Manusmriti in that particular judgment. Opening paragraphs are that. I don't go into the details of that judgment, what happened there and all, for you to go through and then read it. Why I'm saying is, even as recent as 2006, about 20 years earlier, sitting judge of the Supreme Court had to fall back on 2 stanzas of the Manusmriti to decide a particular case, and quotes 2 stanzas from the Manusmriti. Relevancy of Manusmriti in the modern concepts as well. I am repeating the citation. Please note AIR 2006 SC page 1367. In that judgment, His Lordship quotes 2 stanzas. I'll only say the gist of it. The first stanza would say, in the court of law, if the injustice overtakes the justice, adharma over dharma, then the sabhasadan, that is the judge would incur sin. All my advocates friends are happy. Yes, it is the judge who is going to incur the sin. Why should we worry? In the very next stanza, another shloka from the Manusmriti would go to show that sin, if it is 1 rupee, that sin is, if it is 1 rupee, it will be divided into 4 parts. Padau dharma hetyaraha is the stanza that has been quoted from there. If it is a 1 rupee sin, 25 paisa for the offender, 25 paisa for the person who deposes falsely before the court. Another 25 paisa is for the persons who are responsible for the injustice to take over justice. You may say prosecutor, you may say FSL, you may say defense counsel, you may say investigation officer, whomsoever you want. In that 25 paisa, they will all share. And last 25 paisa, remaining 25 paisa will always be on the judge. This was what was told while defining the role of a judge and conduct of a judge and qualities of a judge. Yajnavalkya deals with it in extenso as to the qualities required, eligibility criteria for becoming a judge, and how it should be a justice dispensation system should be. This is how it was there. And then their lordships, you can see the decision in that particular judgment, which goes on a different aspect of the matter. If one is conscious enough, Yajnavalkya Smriti speaks about those who come to the court and speaks the truth. It is the duty of the Raja as well as the court to protect such truthful witnesses. Now you see, today we are calling witness protection, witness protection. 3,500 years earlier, this was spoken to by Yajnavalkya Smriti. Such beautiful things are there. Important doctrines have been there. I have been making my earnest effort to compare that and then make it with the present day modern system. I may come out with some article or a small book or whatever it is in the due course, which will be helpful to all my friends. Paucity of time, I could not deliberate further on the beautiful Hindu jurisprudence we had. So we had what is called customs, which is called achara. Then came the word sadachara. Those which has been followed by the people of virtue are called sadachara. Then we had what is called a family or clan of councils for internal domestic dispute, what we call today Grama Nyayalaya or the Panchayat. Then we had what is called Shri. Shreni Kruta Vyavastha is nothing but your hierarchical system. That means to say civil judge, senior division, junior division, senior division, district judge, high court judge, supreme court judge. That hierarchy was spoken then itself in what is called Shreni or the guild of professional councils handling, especially in the trade and commerce issues. Today we have established now what is called commercial code. Then itself we had a domain experts dealing with the trade and commercial aspects. Then we had called what is called Gana. In the Gana, village assemblies, that is Panchayat, were functioning, which was akin to the present day arbitratory system, mediation, etc., which we require further deliberation in some other platform. Then what was the word used? This Adhikruta and Raja courts. These are all courts which are appointed or presided over directly by the sovereign authority. This how the hierarchy was there. Legal principles that were adopted there was contextual adaptability, that is laws adjusted to dynamically based on, I told about that, Desha, Kala and Patra. Restorative justice in the criminal justice system. System leaned heavily on societal harmony, compensation, rehabilitation, isolated punishment, etc. Judicial trials followed by structured sequence, filing of plaint, written statement, adversarial system, recording of evidence, appointing the expert, commissioners, etc. Then they adopted basically in all trials 4-footed procedure, that is judicial trials will be followed by filing of plaint, filing of defense, presenting evidence, and then final deliberation, that is what is called arguments, then resulting in the judgment. You see what today we are having, the adversarial system was available then also. You would be surprised that how the court hall should look like is also defined, and Yajnavalkya deals with. The judge should sit little height, in a little height on a platform is what is told today's dais, what we sit. And the judge, as he enters the court hall, he must greet by doing namaskaram to the sabha. Today you see what is doing, we are doing it every day. And all subjects who are present in the court should also get up and they also greet the judge in the respect. Look at all these things that was there. Of course, for want of time, I cannot deliberate on the beautiful principles of Kautilya's Arthashastra. I would request all listeners and the organizers that next time in the same lecture series of Honorable Justice Dr. Rama Joyce, in his next birthday celebrations, we deal with the specific aspects like civil and criminal liability, or Kautilya's Arthashastra, how it came helpful in the present day context of modern contextual systems. Now the last part that was left over, that is the integration of these two into the modern digital innovation. I think I have another 2 minutes more. I am sure that time is up. We are required to close it at 7:35. But still, I have 2 minutes to say digital. In every seminar where it is artificial intelligence is being held, I always begin with a quote. World is suffering from natural stupidity and artificial intelligence. It may be too cliche-ridden, or it may be blunt, it may hurt somebody. But fact remains that you don't require, when you want to call a spade, you don't require a computer to call it as a spade. So the Satya can walk without any makeup, even in the midnight, whereas the falsehood requires every day a makeup. So while on the docket explosion, we require a modern mechanism of sorting it out, etc. Unless the judge, unless all concerned with the legal fraternity, our honorable members of the bar, their intelligence, their presentation to the court, their idea of satya, their idea of the values are not put before the court in a proper manner, any amount of your computerization, digitalization will not be of any use, in dispensation of the justice. Yes, computer can help me out in managing my court procedure, court management, recording of evidence. We used to type it earlier, we used to write, then typewriter, now the computer, voice to text, all these things are permissible. But if a person tells the falsehood, computer may not know that it is a falsehood. Whatever he utters, that is being recorded. It is your intelligence here, God-given intelligence, and the moral principles one has to imbibe from our Bharatiya jurisprudence in the modern concepts as well, to understand what is truth and what is untruth. Who is speaking truth, who is speaking falsehood, which no digitalization or computer can do. Human brain with experience, with virtues, will have to look into. In this context, I always recall the judgment of Honorable Justice E.S. Venkatramaya. His Lordship in S.P. Gupta versus Union of India has collected all these aspects of the matter while understanding what are the values and eligibility criteria of a judge. I request all of you to read that judgment and understand how a judge should be. If all of us endeavor in our efforts in getting it into that, I am sure the efforts that we have made today in integrating the idea of the values in our Bharatiya jurisprudence into the modern concepts, modern judicial justice dispensation system, with the, of course, aid of the digital technology. I am sure if that is achieved, the purpose of the organizers' time-taking efforts and then tribute that we can pay to Honorable Justice Dr. M. Ramajoyce, a Dian in the field and a jurist by himself. In that regard, what little I could understand, what little I could assimilate from the text which I have read, which my gurus have taught, I have shared with you. I am happy that such programs are being organized and a good number of people have also joined. I am sure that some portion here, if it is a take home and key points, then the efforts of all concerned, including the mine, would get rectified and it is fruitful. With these words, I would conclude today's lecture. I have time for a couple of questions, if any. Otherwise, we will hear the words of guest of honor as well as the presidential address and then conclude this year's Ramajoyce lecture series with a sense of satisfaction. Thank you, one and all.
Thank you very much for enlightening us, sir. And we are really fortunate enough to listen to you. And I'm sure that all the participants got benefited out of your lecture. So as Honorable Justice sir said, if anybody is having one or two questions, like free to ask questions, because Honorable Justice sir.
Moderator, you can let in Sridevi. Sridevi Patil has raised the hand. Moderator, you can let in her.
Yeah, please, Sridevi Patil ma'am, like if you please ask a question in brief. We are running short of time as per schedule. Sridevi Patil madam.
Sridevi, switch on your mic and then come over. Senior Counsel Ravindranath Kamath has raised hand. Before Sridevi could come, Ravindranath, you can put your question, please.
My lord, somehow.
No, my lord, here. I am Justice Risha here. My lord is only in court. Mr. Kamath, yes, please.
Please, rightly or wrongly, we have adopted English legal system and we are following
Anglo-Saxon
English
system. Anglo-Saxon
system. Now, following the Raja Dharma, can't we change the present legal system, that is the English law system, and go back to the old system where the punitive actions were to be very severe and the crime is to be very less and the litigations were to be very less and
Yes.
settlement is to take place early.
Followed, sir. Followed, sir. Your ambition is right. That requires a lot of efforts. People like you, subjects of this country, will have to work it out in that direction. We can't discount. Rightly or wrongly, as you put it across, this system is in place. In the form of amendments, even after 75 years, if you are not able to amend our penal laws, what it shows? So there is a lack of understanding about these aspects. If somebody knows which is better, for that purpose only this lecture is now organized. Now we are giving you the alternatives. Look at the system what we had, look at the system what we are now. Compare the both. Accept the best practices. You can't discount. See, these are all the laws which have been approved by the Constitution. Therefore, we cannot straight away discount it. It's a long effort. One has to work it out. As I put it across, and at the cost of repetition, I am saying, neither you nor I or anybody in this country cannot discount the existing system. We can bring in the best practices in the form of amendment, which requires a lot of efforts. Somebody has to flag this issue with the elected representatives. It should drive down to the situation of bringing a amendment or a new statute or whatever it is, and then to be tabled before the both houses, get the assent of the president, and then make it as a law. It's a long process, but it has begun. It has begun. We have found out that these things are to be there. It is for the people like you, people like the general persons who are there. Being in a sitting judge, I cannot do this. I can only say, no, the Supreme Court has clarified in many cases, no judge can enact the law. Judge can only implement the law, interpret the law. So such a thing is required, means it is the general public who have to. Now it is the awareness. This program has started across the country. People have joined. Some of our friends have also joined in earlier lectures outside our country who are having interest in our country. So they are all looking at it. See, time has come for us to realize, introspect, find out the laws which are of no use must be deleted, and laws which are required to be, which serves the purpose of the public, that must be brought into, and nothing wrong in borrowing, importing the best principles. See, that such a system is there in the government now. In the governance, accepting the best practices is one aspect that is being done. Likewise, in our judiciary also, it should be done. It is for the people like you, flag it off, write a letter. You have seen a private person has made a bill for the enhancement of the age of the judges. You can also do. You can also write a letter to the assembly. You can also write a letter to the Lok Sabha law minister and then say, sir, these are all the good practices. Why don't you bring in? Who knows? Who knows? It's just a beginning. If one provision of law which can even act today to better administration of the justice, your effort and my effort and the organizers' effort would be fulfilled. Thank you. Sridevi, are you there? Can you come to the
Thank you.
dais, please? Sridevi, are you there? You raised your hand. Hope she is not able
Yes.
to get into it. Mr. You can go ahead with the next one.
Yeah, thank you very much, sir. Thank you for answering. Now, I invite the guest of honor of today's function, Professor Dr. V. Sudesh, sir, Principal, PG Department of Law, University Law College, Bangalore University, Bangalore, to address the gathering. Sir, please.
Thank you. First of all, let me offer my thanks to Honorable Justice SRISHANANDA, sir, if I may use this connection. And like he traveled like the Vande Bharat, very fast.
I remember.
It was good, sir. Of course, not stop because time was not there. But of course, as Justice has promised, some other occasion in my own college, maybe we'll have a more detailed lecture on you, sir. Thank you, sir. With that,
Sure, I also look forward for that.
thank you, sir. Thank you, sir. I just have 4 or 5 points within the time limit that I have been awarded. Let me summarize my remarks like this. First of all, I don't see any conflict between the ancient and the modern because the future need not choose between the wisdom of the past and the technology of the future. It must use technology to realize the enduring values of justice found in the Bharatiya Jurisprudence. Number one. In the Bharatiya tradition, law was not merely a command of the sovereign, it was expected to be consistent with the dharma. Third one, I would like to say, the constitution, as rightly said, represents a modern legal framework, but several of its values resonate with older Indian ethical tradition. What we call dharma is now the rule of justice, constitutional morality. What we call nyaya is justice, socio-economics, politics, etc. Fourth one, sir, we are talking about using technology to offer justice. So dharma is as a method to access to justice. The virtual hearings, e-filings, online cause lists, digital legal service, etc. AI-assisted legal research can potentially make justice more accountable, more reachable. And then, if the ancient conception of justice asked whether justice was morally accessible to the individual, today the digital age asks technologically accessible to the individuals. Finally, I would also want to say that the justice system of the future should not be ancient or modern, traditional or digital. It should be deeply rooted in the wisdom of Nyaya, wisdom of Dharma, firmly governed by the constitution and intelligently empowered by technology. I understand the shortage of time. I would like to thank the organizers, especially Madhavaya sir, for he constantly encourages us to be part of this. So much of knowledge gained, as Justice has already said, we need to do a lot of research and publish more papers because at the undergraduate level, sir, the understanding of jurisprudence is only of the modern jurisprudence, not of the ancient jurisprudence. Though, of course, college in our college, we are exclusively included one unit on the dharma as concept of jurisprudence in our legal theory course. Thank you so much, sir.
Thank you, Professor Dr. Sudesh, sir. And now I invite the president of today's function, Professor Dr. C. Basavaraju, sir, Honorable Vice Chancellor of Karnataka State Law University, HON'BLE, to make his presidential address. Sir, please.
Good evening to all the honorable invitees. Our Honorable Justice Shri SRISHANANDA sir and all the participants of this very enlightened discourse given by our SRISHANAND ji, all our colleagues, law teachers, law professors, advocates, judges, and all the invitees. I think today is a day where we have opened our eyes to the reality of life. One has to look into the understanding of the term dharma. I think it has got a wide meaning. Unlike we casually take dharma is something like religion. No, our Honorable Justice has said dharma is more than that. It is the way of life. Dharma is supreme because it encompasses, provides virtues, goodness, and compassion to the people who really require justice. If everybody understands the real meaning of dharma, I think much of our crimes and wrongs committed in the society can be substantially reduced. But unfortunately, as and when the development takes place in terms of modern technology or in terms of science and technology, fast growth in the transportation, civilization, the inevitability is that there ought to be commission of wrongs, commission of crimes. Probably, if the real meaning of dharma is understood by every individual, looking into the importance of dharma, the tenets of dharma, the principles of dharma encapsulated in our ancient jurisprudence, in the Smritis, Yajnavalkya, and even Vedas, it propagates that people should do good things to the others. People should worship nature, abjure commission of crime. And that should be the sanctity of human life. That is the meaning of dharma. But today, dharma is interpolated, interpreted in a different way, leading to the polarization of our human beings, polarization of our different people. And as a result of which, we do come across today increasing number of crimes taking place in the society. When all people are living in the society as human beings, we need to live with harmony. We live with brotherhood. And that is what we find in real dharma. And I take this opportunity to see that this kind of, these so sacred principles of dharma should be imparted and inculcated from the primary level itself to our children. Our children, if they are more exposed to this kind of the sacred principles of dharma from the birth itself, or from the day when the children get into the schools, I think we can build a good social order, which is very much required for today. We are not finding a proper social order today. It is because of somewhere there is a crossroad. People are deviating, not giving so much of importance and understanding, comprehending the real sense of dharma. And therefore they are deviating, and more number of crimes are being committed, increasing drastically, affecting the humanity, affecting the human values. Today, our Honorable Justice SRISHANANDA Sir has given a very impressive, then very good discourse, which has gone to the hearts of everybody. This is a time where we need to look back our dharma, our sacred principles, the dharma which promotes for equity, equality, and justice and social order. If they are in fact built, I think we can reform the society, bring back the glory, our earlier ancient glory to our society. I always say, as a professor of law, that the entire Indian Constitution is built on the premise of the sacred principles of dharma: equality, brotherhood, justice, and fraternity. And if this is understood by all, If this is taken care of by all from the early days itself, I think much of our problems would be solved. We need not get into the various conflicts. We need not get into the various wars which are taking place for unnecessary reasons, taking away the huge lives of people. And I'm sure that it is only through dharma that it is possible to ensure the social order in the society, bringing all the neglected people, bringing all the people who are scattered everywhere can be brought together in one platform to understand the efficacy and importance of dharma. I take this opportunity to thank our Shri Mahadevaya and all my colleagues taking so much of a risk in conducting this kind of a very valuable, very educative, eye-opening discourse given by such an eminent our jurist, our Honorable Justice Shri Sheshanandaji. We will be looking forward for such kind of a continuous, your discourse will definitely reform the entire society which is at crossroad now because of lack of the sacred principles of dharma. There is a want of dharma today, and because of the lack of dharma, I think people are deviating. People are at the crossroad, committing various crimes, disrespecting the others, not giving respect to the elders. And I think this is the right time where even if we have completed 75 years of our constitution came into force, at least now we have to realize, we have to make every others to realize the importance of dharma in ensuring social order, social harmony, and equality in the society. Thank you so much for inviting me to this very important discourse given by our Justice Sheshananda sir. And I thank all the invitees and sir also for this hearing my presidential note. Thank you so much, sir.
Thank you. Thank you. Thank you very much for delivering a presidential address, sir. Now it is time to invite Dr. Krishna Shekhar Sharma, Assistant Professor, Central University of Karnataka, Kalburgi, to deliver vote of thanks. Krishna Shekhar Sharma, sir.
Thank you, sir. Namaste, everyone. Myself, Dr. K.M. Krishna Shekhar Sharma, Assistant Professor, Department of Law, Central University of Karnataka. Take this opportunity to propose vote of thanks, not just for this lecture session, but for the whole of the lecture series. Please bear with me because this vote of thanks or expression of gratitude is not a brief one. So, because this particular lecture series is not a ordinary one. This lecture series organized by the Vignaneshwara Pratisthana Trust in collaboration with the Central University of Karnataka and the Karnataka State Law University, HON'BLE. This is the 6th lecture series in commemoration of the birth anniversary of revered jurist, statesman, and former Chief Justice, Justice Dr. M. Rama Joyce. This is conceived and conducted with the objective of remembering the enduring legacy of Justice Dr. M. Rama Joyce and of providing an intellectual forum for meaningful dialogue on Indian jurisprudence, law, justice, and the civilizational foundations of our legal tradition. The lecture series featured eminent academicians, jurists, judges, advocates, and scholars from different parts of the country. Among those who graced the series were Professor Bhattu Satyanarayana sir, Vice Chancellor, Central University of Karnataka; Professor Srinivasa Varkedi sir, Vice Chancellor, Central Sanskrit University, New Delhi; Professor Prahlad R. Joshi sir, Vice Chancellor, KBSAS University, Nalbari, Assam; Professor Madhumita Sarkar, Madam, Dean, School of Legal Studies, Assam University, Silchar; Professor Dr. T.R. Subramanya sir, Dean, CMR Law College, Bengaluru; and Professor Dr. C. Basavaraju sir, Vice Chancellor, Karnataka State Law University; Professor V. Sudesh sir, Bengaluru University, besides several distinguished judges, legal scholars, and resource persons. This concluding lecture of the series is delivered today by Honorable Justice Shri SRISHANANDA sir, Judge High Court of Karnataka. His illuminating exposition, enriched by references to the Vedas and Upanishads and supported by thoughtful illustrations drawn from life and jurisprudence, made the subject both intellectually profound and accessible to the audience. Sir, your lecture offered a compelling reminder that the Bharatiya legal tradition is not merely a body of rules, but is deeply rooted in ethical values, duty, justice, and the larger quest for social harmony. Thank you very much, sir. On behalf of the Vignaneshwara Pratishtana Trust, Department of Law, Central University of Karnataka, and KSLU Bangalore, KSLU Hubli, I express my profound gratitude to you, sir, for delivering such an insightful and thought-provoking lecture. I place on record our sincere gratitude to Professor Dr. C. Basavaraju, Vice Chancellor, Karnataka State Law University, Hubli, for graciously presiding over today's program and lending distinction and academic dignity to the occasion. Thank you very much, sir. Our heartfelt thanks are also due to Professor V. Sudesh, sir, Principal, University Law College, Bengaluru, for joining us as the guest of honor and for enriching the program with his valued presence and support. Thank you very much, sir.
Thank you so much.
Our sincere appreciation goes to all the eminent legal luminaries and distinguished guests who, by their presence and participation, have enhanced the stature and intellectual richness of this lecture series. I also express our deep gratitude to Professor Battu Satyanarayana sir, Vice Chancellor, Karnataka Central University, whose encouragement and support have been invaluable to the successful conduct of this lecture series. And also to Professor Basuraj M. Kubakadi, Dean School of Legal Studies, Central University of Karnataka, for his continued cooperation in all means. Our sincere thanks are due to the faculty members and non-teaching staff of the University and School of Legal Studies, whose cooperation has greatly facilitated the organization of these programs. I also thank Dr. Vaishnavi, Assistant Professor, Central University of Karnataka, who undertook the responsibility of welcoming and introducing the distinguished speakers and guests on this last day of the lecture series. Thank you, madam. I offer my respectful thanks to the serving and retired judges from the district judiciary to the High Court who graciously spared their valuable time to attend these lectures. Their presence has been a source of encouragement and inspiration to all of us. My sincere gratitude goes to Sri Basaraj Patil Sedamji, President of the Vignaneshwara Pratishtana Trust, and to all the trustees, especially to Mahadevai ji for their steadfast commitment and collective support in furthering its academic and research-oriented objectives. I particularly acknowledge the painstaking efforts of Sri Amit Kumar Deshpande sir, Senior Advocate, High Court of Karnataka and Trustee, Vignaneshwara Pratishtana Trust, and Professor Girish Kesi sir, who played important role in coordinating and organizing the lecture series. I also place on record my appreciation for the technical assistance rendered by the PG students and research scholars of the School of Legal Studies, Central University of Karnataka, particularly Saikat Ghosh, Nikhil Sathe, Tapesh Meghwal, and Aditya Madhav, whose behind the scenes efforts contributed significantly to the smooth conduct of the programs. I extend my heartfelt thanks to the principals and faculty members of various law colleges, the advocates, and above all the students who participated enthusiastically in the lectures. Their presence and intellectual curiosity have given true meaning to the objectives of this lecture series. In truth, the success of an academic endeavor of this nature cannot be attributed to any one individual. It is the collective result of innumerable minds that conceived it, hands that supported it, hearts that believed in it, and people who gave their time, knowledge, and goodwill to make it possible. Therefore, to everyone who contributed, directly or indirectly, to the success of this sixth lecture series, to everyone who extended a helping hand, and to everyone who participated with goodwill and encouragement, I offer my heartfelt and boundless gratitude. The success of this lecture series belongs entirely to all of you. The Vignaneshwara Pratishtana Trust is privileged to carry forward the intellectual legacy associated with Justice Dr. M. Ramajoy sir, whose vision and dedication gave a distinctive direction to the study of Bharatiya jurisprudence. The Vignaneshwara Bhavan Research Center at Martur, founded in his memory jurisprudence, remains a humble yet significant center dedicated to research, study, and the dissemination of India's ancient, legal, and intellectual heritage. I earnestly invite each one of you to visit the Vignaneshwara Bhavan Research Center at Martur, and whenever possible to bring along your students, colleagues, friends, and I'm confident that a visit to the center will provide an opportunity to experience the intellectual heritage and research activities associated with the trust. I also request you to visit the official website of the Vignaneshwara Pratishtana and remain connected with its forthcoming academic and research initiatives. And also, I would like to mention that all the lectures that are conducted under this lecture series are available on Department of Law, Central University of Karnataka YouTube channel. With this humble request and with a profound sense of gratitude to every distinguished guest, scholar, judge, academician, advocate, student, organizers, and well-wishers who has been part of this intellectual journey, I bring this vote of thanks to a close. Thank you. Dhanyavad.
ನಮಸ್ಕಾರ.
Thank you, Krishna Shekhar Sharma.
ಶ್ರೀ ಎಸ್ ಆರ್ ಸೂರ್ಯನಾರಾಯಣ ರಾವ್, ಡಾಕ್ಟರ್ ವಾಸುದೇವ್ ಸೇಡಂ, ವಿ ಕೃಷ್ಣನ್ ಮತ್ತು AR ಮುಕುಂದನ್ ಫ್ರಮ್ ಚೆನ್ನೈ, ಶ್ರೀ ಎಂ ಲಕ್ಷ್ಮೀನಾರಾಯಣ್, ಶ್ರೀಮತಿ ಸ್ನೇಹ ಸಪ್ರೆ ಫ್ರಮ್ ಭಂಡಾರ್ಕರ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್, ಶ್ರೀ ರಮಾಕಾಂತ್ ಶರ್ಮಾ, ಜಡ್ಜ್ ಸಮಷ್ಟಿಪುರ್. ವಿ ಥ್ಯಾಂಕ್ಸ್ ಫ್ರಮ್ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ, CUK and KSLU. Thank you, Ananda.
And I also thank Krishna Shekhar Sharma, Assistant Professor, CUK Kalburgi, for rendering a wonderful vote of thanks. And I also thank Professor Dr. N. Satish Doda, Dean Faculty of Law, Bangalore University, who is also present here. Now I request Madevaya Kardalli sir to speak few words and Shanti Mantras.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. ತಮ್ಮೆಲ್ಲರ ಬೆಂಬಲದಿಂದ 6ನೇ ಉಪನ್ಯಾಸ ಮಾಲೆ ಯಶಸ್ವಿಯಾಗಿ ಸಂಪನ್ನ ಆಯಿತು. ಶ್ರಾವಣ ಮಾಸದ ಮೊದಲ ದಿನ ಉತ್ತಮ ಶ್ರವಣ ದಾಸೋಹ ನೀಡಿದಂತ ಗೌರವಾನ್ವಿತ ಶ್ರೀ ಶ್ರೀಶಾನಂದರಿಗೆ ನಾವು ಮತ್ತೊಮ್ಮೆ ಧನ್ಯವಾದಗಳನ್ನು ಹೇಳ್ತೇವೆ. ಇಲ್ಲಿ ಭಾಗವಹಿಸಿದಂತ ಎಲ್ಲ ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳು ಮತ್ತು ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ಎಲ್ಲ ನಮಗೆ ಸಹಕಾರ ನೀಡಿದ್ದಾರೆ. ಕೇವಲ ಆನ್ಲೈನ್ ಅಲ್ಲ, ಆಫ್ಲೈನ್ ಅಲ್ಲಿ ಕೂಡ ಸುದೇಶ್ ಸರ್ ಇರ್ಬೋದು, ಪ್ರೊಫೆಸರ್ ಸುದೇಶ್ ಸರ್ ಇರ್ಬೋದು, ಪ್ರೊಫೆಸರ್ ಬಸವರಾಜ್ ಸರ್ ಇರ್ಬೋದು, ಎಲ್ಲರೂ ಅಲ್ಲಿ ನಮ್ಗೆ ಹೆಲ್ಪ್ ಮಾಡಿದೆ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನಕ್ಕೆ. ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಎಲ್ಲರ ಸೇವೆಯನ್ನ ನಾನು ಸ್ಮರಿಸ್ತೇನೆ. ಭಾಗವಹಿಸಿದ ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು. ಪ್ರತ್ಯಕ್ಷ ಪರೋಕ್ಷವಾಗಿ ಭಾಗವಹಿಸಿದಂತ ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು. ಈಗ ಶಾಂತಿ ಮಂತ್ರ. ಓಂ ಸರ್ವೇ ಭವಂತು ಸುಖಿನಃ, ಸರ್ವೇ
ಸಂತು ನಿರಾಮಯ, ಸರ್ವೇ ಭದ್ರಾಣಿ ಪಶ್ಯಂತು, ಮಾ ಕಶ್ಚಿತ್ ದುಃಖಭಾಗ್ ಭವೇತ್. ಓಂ
ಶಾಂತಿ ಶಾಂತಿ ಶಾಂತಿ. ಸನ್ಮಾನ್ಯ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ರಾಮಾಜೋಯಿಸರ ಹೆಸರು ಈ ಮೂಲಕ ಮತ್ತೊಮ್ಮೆ ಎಲ್ಲರ ಮನದಲ್ಲಿ ಇರ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ನನ್ನ ಮಾತಿಗೆ ವಿರಾಮ ನೀಡ್ತೇನೆ. ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು.
Good night all. ಶುಭರಾತ್ರಿ.
ಶುಭರಾತ್ರಿ ಸರ್, ಶುಭರಾತ್ರಿ ಎಲ್ಲ.
Thank you.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಮತ್ತೆ ಭೇಟಿ ಆಗೋಣ.